Hello, everyone. Thank you so much for joining us today. My name is Juan Carlos Brando, and one more time, I'm so happy to be here with all of you, sharing some information about immigration with one of the attorneys in the law firm of Margaret W. Wong. As usual, on Thursdays we have different attorneys, but one of my favorite attorneys to talk about immigration is Attorney Francis Fungsang, who is one of the doctrinaries in the law firm of Margaret W. Wong and Associates. So let's welcome the attorney Francis. Good afternoon, attorney. How are you doing today?
Good afternoon. I'm good.
Thank you. Yeah, I'm doing good as well. And well, I've been wondering about these laws that are been instated in some states like Florida, Georgia, Texas, because of what some immigrants have done, that they have committed horrible crimes. Um, and these states have passed, in the case of Georgia, is the 110 HB 1105 law, which is the law that will check you into or in front of immigration. And if you don't have a legal status here, they will either deport you or put you in removal proceedings. So in the past, we've had the 287G program, and some people are maybe scared about it. But with these kind of programs, what are the limitations that we have as immigrants in the United States?
Well, the issue with these kind of programs, there are a couple of different issues. Number one, the most important thing is that the Constitution says that immigration is a federal issue. That means the Homeland Security, ICE, they control immigration and they deal with enforcement of immigration laws. So not states, not local cities, not the local police departments. The Immigration Service enforces the immigration laws. Okay. Now 287G from years ago, that program almost deputized police officers and police departments to help the Immigration Service to enforce those laws, but those have mostly been gone away. So the issue with these is, number one, constitutional. Are these laws that the states or cities are passing, are they even legal? Because they're taking upon themselves to enforce immigration. And number two, it also prevents trust in the local police department. Because if immigrants are afraid of being deported or afraid of being hassled by the police, even if they're victims of crime, they might not report those crimes. They might not agree to assist the police in their investigations. And so there isn't that local level of trust in the city's department.
So in this case, for example, one of the other issues that immigrants may have is to travel across the country. So we have been talking about the real ID since 2016, if I'm not wrong, and it has been delayed and delayed, even with the former or the past term of Donald Trump, and now with President Biden. But it's supposed to come in effect in May next year, if I'm not wrong. So what's going to be the issue for people that don't have legal documents in the United States to travel either on a plane or train or in a car?
Well, I believe that the Real ID Act, that means you have an ID that has that star in the top right corner that shows it complies with the Real ID law. That is only for airplane travel. That means domestic airplane travel. It doesn't change anything about international travel. You still need a passport and a visa to come into the United States, or a green card, or travel permission. But domestic travel within the United States on an airplane, you will need that ID. So if you're not eligible to get that ID, or you don't have any form of ID, then unfortunately you'll be traveling on the road driving around on buses or whatever.
What if I don't have the real ID, but I have a passport from my country?
Well, technically, the passport should comply with the real ID requirements because most countries, their passports are compliant. But then when you use a passport, that could raise questions about what your immigration status actually is, especially if there's no valid visa in there. So we usually don't recommend you use your passport to travel domestically if you don't have legal status, because if you're in an airport that has a CBP office, TSA could just give a call to CBP and ask them to come down here. Maybe that happens, maybe it doesn't, but it's a risk.
Okay, we need to be careful starting from next year. Right now, we are kind of okay, but next year things are going to be tougher. So we just need to be more careful about where we're going to travel, what we're going to do, even to work or even to drive. Driving is one of the easiest ways to get in the hands of immigration when we have these kind of laws that could put you in removal proceedings just for driving without a license. So just be aware of that. And if you don't have the advice of an immigration attorney, please just give us a call. And the phone number is 216-279-3984. Try to make an appointment with the attorneys in the law firm of Margaret W. Wong, and they should give you, if you have any chance of getting an immigration status, they will give you a way to put it, to get an immigration status. If you don't qualify for any immigration status, they will let you know, and they will tell you we just need to wait, or you need to just be careful with this, and that. So just give us a call for advice, 216-279-3984. We have the first question coming in, and it says, Hi, I have a final order and have been reporting to ICE. Just want to know if the work permit is coming now for 1 year or 5 years, and if I can file it online, or if it has to be on paper. Thank you.
Okay, so I believe that if you have a final order and you're reporting to ICE on order of supervision, that means you have the form I-220B as in boy. Then you are eligible to apply for a work permit if you can show that you're having financial difficulty and need to support yourself or your family. Now, I believe that category is C18. You might have to double check that category. But yes, you can apply right now. You have to file by paper, not online. Some types of work permits you can file online, including international students and TPS, but not for the order of supervision work permit. And I believe it's only for 1 year. Some work permits are valid for 5 years now. That's if you're applying based on pending asylum, or if you have a cancellation of removal case, or you have a pending I-485 green card application case. Those are valid for 5 years, but I believe the order of supervision is only for 1 year.
Thank you very much, Attorney Francis. Don't forget, the phone number is 216-279-3984 for more information, and you can call anytime between 8 in the morning and 5 p.m. Eastern Time. I repeat, 216-279-3984 is the phone number that you need to call to talk to the attorneys in the law firm of Margaret W. Wong and Associates. Dady is saying, good morning, good to see you guys today. I have a question. I came on a K1 visa and got married within 90 days. Now I'm waiting for the marriage certificate so I can apply the I-765 along with the I-1485. Since it's going to take a while for the EAD and green card to be approved, would it be okay to go to college? I used to go when I was a student here and take some classes while waiting, or better to wait till EAD or green card is approved? Thank you so much.
Okay, so that depends on the university or college that you're going to. What documentation will they require for you to be admitted and enrolled to attend classes? Sometimes they ask for proof of immigration status, sometimes they don't, okay? If they want proof of your immigration status, then I would wait until after you have filed your I-485. Then you'll get that receipt notice from immigration in the mail about 2 or 3 weeks later, That receipt notice is proof that you are allowed to stay in the United States because you have a pending green card application. You can show that receipt to the college to show that you're legally here. If they don't care about your immigration status, then you can start school right away. It does not affect your ability to get the green card to take classes.
Okay, thank you very much. We have a bunch of questions coming in right now. So, well, this is good because we have a lot of people uh, asking questions, but somehow I know that people are worried about what's coming next year regarding to immigration. Um, the next question is: Hi, I am a psychologist and I live in France. I would like to know if I can get an EB2 visa to migrate to the United States.
Okay, so the EB2 is a category of employment-based green card. And so that's employment-based second preference category. Now there's two different EB2 categories. There's what's called the National Interest Waiver, or NIW, and then there is the employer-sponsored category for advanced professionals if you have a job offer from a US employer. So if we're talking about the second one, that's if there's a US employer offering you a job, they can sponsor you in the EB2 category if the job requires at least a master's degree or at least a bachelor's degree and 5 years of experience. Then you are an advanced professional. The employer can do the paperwork to bring you to the United States, and it would take probably about 2.5 to 3 years, but then you would get the EB2 visa in your passport and you would come to the United States and enter as a permanent resident. Now, if you're talking about the first option, the National Interest Waiver, that is self-sponsored. That means you're sponsoring yourself without having a job offer in the United States, but you have to show that your presence in the United States will be in the interest of the United States. How will your presence benefit the United States as a whole? Okay. Is your field of study or research, is it beneficial to the United States as a whole? Number two, are you well prepared to take on whatever project you are planning? And number three, why is it that you should be able to skip the labor certification and the job offer requirement and go straight to the I-140 petition instead of finding a job in the United States? Okay, so if you have done a lot of research and have publications in psychology, that would be very helpful to the United States because of all of the disorders or lack of treatment options here. That could be an option. If you want to start your own psychiatry business in the United States and you've already done that, then that could be a reason why your presence could be helpful. And so I would recommend you talk to one of the lawyers in our office to talk about your plans and your CV and background to see if you would qualify for the NIW.
Thank you very much, Attorney Francis. And don't forget, we have attorneys that have a lot of expertise in these areas of work or employment-based visas, like Attorney Francis. He's one of the attorneys that I know is really, really good in this kind of processes and processing times, asking for all of the documents. So if you want to go ahead and make an appointment, just give us a call. The phone number is 216-279-3984, 216-279-3984. Will they cancel I-130 petition for parents?
So I think you're probably concerned about the new president coming in and a lot of talk about changing the immigration system, making it harder to immigrate. Now, the ability, family-based immigration, that means filing for a spouse, filing for a parent, filing for a child. These abilities have been here for decades, a very long time. I don't think that these categories are going anywhere. What's going to change is deportation policies. It's probably going to increase. Asylum policies, it's going to be more difficult to apply and to be approved. And pretty much anything related to removal or deportation. All the other categories, family-based immigration, employment-based immigration, I don't really see significant changes happening there.
Thank you very much, Attorney Francis. And we have another question. It says, I have two kids born in the US, entered on a B2 visitor on 2013. My kids are 11 and 2. Healthy, thank God. Would it be bad if I file for asylum now?
Well, I mean, the question is whether you qualify to apply for asylum. So we've mentioned this in the past. For asylum, there's what's called a 1-year rule. You're supposed to apply for asylum within 1 year of coming to the United States, unless you have a very good reason why you waited so long to apply. So what are some of these reasons? Is there a change in your personal circumstance or a change in the conditions of your country where when you came in 2013, you did not qualify for asylum, but now you have a reason to apply for asylum? Has there been a change in circumstances? Number two, if you were a minor back in 2013, and so you didn't have the capability to apply for asylum, and now you are an adult, that could be an exception that qualifies as an exception to the 1-year rule. Or if you had legal immigration status from 2013 to now, and you recently fell out of status or overstayed, that could be a reason, because if you had immigration status before, you didn't necessarily need to apply for asylum at that time. So that's one thing to consider. Do you meet an exception to the 1-year rule? Otherwise, the Immigration Service will make it more difficult to approve your case. And number two, what is your reason to apply for asylum? Do you think you'll be harmed or threatened if you go back? And so that means, do you have a valid claim? What would happen to you if you went back to your home country? And if it does not meet the level of what's called persecution, then the Immigration Service would not approve the asylum either, and you risk being put into deportation if you do not win your asylum case.
Thank you very much, Attorney Francis. And well, we have a lot of interesting questions today. And well, this is a case that could be really tough, not only because of proving that they have a case, but also why didn't you file in the first year, which is one of the major issues that people may have. Okay, so next question says, hi, my son is studying avionics. We live in Dallas, Texas, and he's working for a private jets company. His boss wants to help him with his immigration status. I filed asylum and he's included, and he was 12. Now, when we came, now he's 22. What is the best process for him? I remember I filed asylum within 180 days after entering the US.
All right, so the first question is going to be, what is the status of your asylum application? If it's still pending with the Immigration Service after all these years, and you and your son have been applying for work permits, so the employment authorization document, then you're both allowed to remain in the United States while you're waiting and also to work. Now, having a pending asylum case is not technically an approved immigration status. It is not a visa status. It is not student status or H-1B status or even TPS. So you would not be able to change from pending asylum to a work visa or pending asylum directly to an employer-sponsored green card. If this company is willing to help your son, that means sponsor him for the green card, they can go through step one, which is the PERM or labor certification. That's an advertising process where we post the job in the local newspaper to see if there are qualified US workers available for the job. Number two is the I-140. That's where we show that the employer can afford to pay the salary and that your son qualifies for the job with the necessary experience or education or licensure. And then the third step is the actual green card application. If he had maintained immigration status in the United States, he can do the green card in the United States, but a pending asylum is not immigration status, so you would have to complete step three at the US Embassy in your home country and be interviewed for the green card at the US Embassy. If he's approved, he gets the visa stamped into his passport and comes into the United States as a permanent resident. Since he's under the age, since he's had a pending asylum since before the age of 18, none of this time counts as unlawful presence, so he does not need a waiver to apply for the visa. That his pending asylum has protected him this whole time.
Okay, so he could go straight and file for this young man as an employee.
Well, and I also see that there's a follow-up. He says now we have TPS. Okay,
Yes.
okay, that's a little bit different now. The current policy is if you have TPS, technically that is a valid non-immigrant status, but if you had any unlawful presence before you were granted TPS, then you would not be able to do the green card in the United States. So if you came on the visitor visa and then within that 6 months, you got the TPS, so there are no breaks, you could possibly do the green card here. That's step 3. If there is a break, then what I would recommend is you apply for a travel permission based on the TPS. You leave the United States, come back in on the travel permission, then you can do the green card in the United States because you've been admitted into TPS status. Now that policy just changed within the past 2 years. We don't know if the new administration will change it again, but that's something for you to consider. If you don't want to go through the US Embassy process, you apply for the travel permission, leave and re-enter the United States with the TPS.
Okay, thank you very much, Attorney Francis. Very clear answer for this case. And yeah, I would call the attorneys in the law firm of Margaret W. Wong. The phone number is 216-279-3984. 216-279-3984 is the phone number that we need to call in order to make our appointment in our city and talk to the attorneys. They will have an answer for our immigration status. 216-279-3984. Hi, my son was murdered 2 years ago. He was 17. He used to live with his mom. Would I qualify for a U visa even if he wasn't living with me?
Okay, so first of all, I'm sorry to hear about what happened to your son. Very sad and it's unfortunate. The U visa is typically for victims of qualifying crimes. Now, murder is definitely a qualifying crime. But the question is, would you as the mother qualify as a victim? Now, there's what's called a direct victim and indirect victim. Direct victim is if you were the intended target and you were harmed, okay? Indirect victim is when maybe your child was the actual direct victim, but you were indirectly harmed because of that. Now, there is a special provision in the law that allows for a very serious crime like murder to qualify as a victim of crime, even if you are not the direct victim. And so the murder of your child is one of those categories. So I think you would qualify for the U visa. Then the question would be, would the police department be willing to sign the U visa paperwork to allow you to apply for the U visa? Okay. So I'd recommend you talk to an attorney. This is not an easy type of case to handle. So definitely talk to an attorney to get some help.
Okay, thank you very much, attorney. And well, we are very sorry for this case. It's really sad. It's a very sad case. We wish that these things wouldn't happen to anybody. Good afternoon. I have my court on December 3rd. I'm in removal proceedings in Arizona. Entered through the border. I don't have much money. Can I go without an attorney?
Okay, so you can go to the hearing without an attorney, but then the question is going to be, what is your goal for the removal proceedings? Are you going to apply for asylum? Do you want to just leave the United States? Are you eligible for anything else because of what country you're from or your circumstance? Okay. the judge is not necessarily going to explain all of your options to you. So it's definitely better for you to have an attorney. Now, if you just need more time, you could go to this hearing by yourself and tell the judge, I need more time to find a lawyer. And then the judge will reschedule your hearing for maybe 1 month later, 4 months later, 6 months later to give you more time to find a lawyer. But yes, technically you can go to the hearing by yourself, but the judge will start asking you questions about your plans. And if you're not sure what your plans are, then I would recommend just asking for more time so you can find a lawyer.
Okay, thank you very much, Attorney Francis. I think we have time for a couple more questions. And this question is, I am gay from Pakistan. If I go back, I would get murdered or killed, I assume, by the government. Would I be able to file for asylum?
Okay, so you apply for asylum. Like I said, there's two main parts. Number one, are you applying within 1 year of coming to the United States? And if you're not applying within 1 year, do you have a good reason for waiting so long to apply? And number two, would you be harmed or threatened or persecuted if you go back to your home country? Now, maybe you were harmed or threatened in the past and you're afraid it will happen again. Or you think that because of your circumstance now, if you go back, you're afraid it could happen in the future. So if you feel that you could be harmed or killed if you do go back to your country, and you feel like the government or the police would not be able to help you, and you feel like you couldn't be safe by going to another part of the country in Pakistan, then yes, I think you definitely should apply for asylum and have the opportunity to be heard.
Okay, thank you very much, Attorney Francis. And we have time for one more question. And it says, I am Puerto Rican, married to a Mexican. We live in Mexico currently. He has never been in the United States. What is the fastest way to get his immigration status and get him to live in the U.S.?
Okay. So, the fastest way to get him to the United States would be for him to apply for a visitor visa, like a tourist visa. That's a B1, B2, or a border crossing card. Now, because he's married to a U.S. citizen, the U.S. Embassy probably won't give him the visitor visa because they might think that he's just trying to come to the United States to live permanently. Okay, you can only get the visitor visa if you're coming to visit the United States as a tourist. So then the next best option would be to, if you sponsor him for the green card, because as a Puerto Rican, you are a U.S. citizen, you can sponsor him to immigrate to the United States. First, you would file the I-130. That's the marriage petition. And then you would file the immigrant visa process through the State Department. Eventually, he'll be scheduled for an interview at the U.S. Embassy in Ciudad Juarez in Mexico for the immigrant visa to come to the United States. Now, that process will probably take between 2 to 3 years. So it's not fast, but at least he'll be a permanent resident when he gets here.
Perfect. Well, our time is up for today, Attorney Francis. So thank you very much for your time, for your knowledge. Well, do we have time for one more question? Would you be safe from deportation if you are married to a U.S. citizen?
Well, that depends on what the new administration's enforcement policies are. What is their priority system for deportation? The previous administration, people who came in more recently, people with serious criminal records, people who pose a danger to the United States, people who engaged in fraud, those were higher priorities. Now, we don't know the priorities for the new administration. Maybe if you're being married to a U.S. citizen, you're a lower priority, but typically just being married to a U.S. citizen doesn't really change anything because you're still undocumented, or you might still have a criminal record, or any one of those enforcement things.
Okay, thank you very much, Attorney Francis. Well, now we are dismissed. So thank you very much. See you next time. And thank you so much for sharing all of your knowledge.
All right, you're welcome.
Thank you very much. Don't forget, the phone number is 216-279-3984, 216-279-3984. Talk to the attorneys that really know about immigration and that will guide you in the process that you may qualify for. So the phone number is 216-279-3984. Attorneys in the law firm of Margaret W. Wong and Associates. Thank you so much for having us today, and have a good lunch, and see you next time.